going to say, I owe you an apology. I shouldn't have been joking around with you. You are correct, and I am going to follow your idea. All right?
Oh, okay. Thank you.
An apology. I shouldn't have been joking around with you. You are correct. Sharon suggested that I keep my mayor's report short, and I was like, well, I appreciate your confidence.
Should we take odds offline? the over under.
And we are live.
All right, welcome everyone. Today is the 22nd of June. Thank you for joining our the full council meeting of Gulf Manor. And would you please join me as you're able for the Pledge of Allegiance to our Republic. I pledge allegiance to the flag.
To the flag of the United
States of America.
To the
republic
which
for
stands one nation,
under God,
indivisible,
liberty,
liberty,
justice for all.
All right, may we have a roll call for quorum, a poll for quorum, please.
Okay, bear with me here for just a second because I can't find my notes. Somewhere. Here we go. Mr. Betcher.
Present.
Ms. Cheney.
Present.
Mr. Knipp.
Present.
Mr. Pridenoff.
Present.
Ms. Snyder.
Present.
Mr. Van Harn.
Present.
I take that as a present, Mr. Mayor. Everybody is present and accounted for.
Wonderful. I asked our attorney, our solicitor, Mr. Donnellan, to speak on how the recent Supreme Court decision may affect our NDO, our non-discrimination ordinance here in our community. And we also have on the agenda an executive session. Mr. Donnellan may not be able to stay for the full meeting, so I've requested that that be moved. His report in its entirety in the executive session be moved to the front of our agenda. If I don't have any objection, I'll take that as unanimous support for us doing so. And without hearing otherwise, I will go ahead and ask Mr. Donnellan to get us started.
Thank you. First, let me do the easy part. We have one piece of legislation under my report on the agenda this evening. It's resolution 2020-7. Do you want to make a motion to read by title only?
Do I have a motion?
Motion to read by title only. Quick question. Do we need to approve the agenda first?
We do. I was rushing through that, asking if there was an objection to the change in the agenda. But yeah.
Motion to approve the agenda with Stefan's, with Mayor Densmore's emendation to have the solicitor's report done first.
Second.
That would also be with the executive session moved up front as well.
I'm sorry, who motioned?
So motion to approve the agenda with the emendations of Mayor Densmore to have the solicitor's report first and the executive session thereafter.
Second.
Who was
Those in
that?
favor?
Roger? Okay. Thank you.
So we vote. All in favor, aye. Did we get that?
All in favor?
Aye.
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 I take that as unanimous.
All right. Did we then have a motion to read resolution 2020-7 by title only?
Motion.
To read by title only.
Second.
Roll. Do we need a roll on that?
Vote,
No.
voice, all in favor.
All those in favor?
Aye.
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 No, without objection, I take that as unanimous. Please proceed.
This is a resolution approving the process to receive and disperse coronavirus relief funds. I need a motion, a second, and I'll give an explanation and we'll do a roll call vote.
So motion.
Second.
Who made the motion? The guys all sound alike, so sorry.
It was
So Mr.
Eric.
Prydenoff- So Mr. Prydenoff, and who made the second?
Mr. Van Harn.
Got it, thank you.
Thank you, Ms. Snyder.
This is a resolution that's required by the legislation passed last week in the General Assembly and the Senate for disbursement of coronavirus relief funds. Each community was required to register through the Office of Budget Management. I believe Mr. Hirth and Mr. Lanzer took care of that last week. The second component is to pass this resolution. The purpose of the resolution is to specifically commit us that the monies received will be spent for those purposes as outlined in the federal statute and any guidelines which may come down from Ohio. Secondarily, it requires that if funds have not been appropriated or earmarked by the end of October, they're to be returned to the county, and then all funds must be spent by the end of December. Each jurisdiction throughout the state is asked to pass this resolution to confirm this. We added two other sections to it. One was to establish a very specific fund into which these monies will be deposited, so they'll not be mixed into the general fund. And then lastly, to authorize Mr. Hirth and Mr. Lanzer as necessary to execute such additional documents that may be required. If any of you are familiar with the PPP program for private enterprise for payroll, it changes almost by the week. So that added language in there will allow us to continue to move quickly to get those funds once they're released. It is my understanding, as of Friday, the governor had not yet signed it. It was on his desk, had not signed it. They anticipate either late Friday or today it will be signed. The monies will start flowing through within the next week. So they'll first go to the county, then the county allocates to each local jurisdiction. And then it's up to us then to start recapturing some of this money into our budget for expenses we've already had and those we will have for the coronavirus impact. Questions?
Yeah, what's the range of the funds and what do you kind of know that we may need it for or use it for?
Yeah, what we can use it for right away is to reimburse ourselves for any PPE we have purchased, have funding available to purchase additional PPE. There's some guidance coming down on payroll reimbursement where you may have had hidden costs, like someone had to stay home for 3 days and we had to pay overtime to someone else to work. So some of that is trying to be shaped up at the state level to broaden it. There's another suggestion that more monies will be coming from the state of Ohio. The problem right now is the General Assembly, the House of Representatives, has adjourned for the summer. So they will not be back in session until September. So I was part of a call on Friday where the discussion was to, first of all, perhaps move those deadlines back from October and December, and then ask them to very quickly approve it, or the Municipal League is looking at potentially bypassing the General Assembly and going to the Ohio Controlling Board, which controls the disbursement of funds, so that they can keep these funds flowing. A lot of communities have significant budget impacts with loss of tax revenue. And that's one of the things they're pushing, is to open it up to reimburse for those losses of tax revenue, not just actual monies expended, but actual monies lost.
I would add that this is not to be confused with a county program where they're going to be dispersing at 25 million, I believe. And they've been specifically letting everyone know that the spending requirements around it, or what you can use the money for, is much more flexible. We'll be contracting directly with the county, telling them what we would like to spend the money on, and they'll help us with the language to ensure that we'll be able to do that. So it's a separate fund than what this is, but more coming through the state than the county. Yeah.
So my understanding is we could approve this, basically get whatever funds may be available, put it in an account, and if we end up not using it all, we give it back to the state.
Correct.
Correct. And then,
That's
but they kind of tell us what we can and can't spend it on, and that changes. All right. So.
Correct.
Any other questions? All right, Mr. Hirth, will you
Okay, Mr.
put us on a
Betcher,
roll call?
Yes.
Ms. Cheney,
Yes.
Mr. Knapp,
Yes.
Steinhoff,
Yes.
Ms. Snyder,
Yes.
Mr. Van Horn.
Yes.
Resolution 2020-7 passes.
The next topic is to give you an update as it relates to the non-discrimination ordinance, to set our public hearing, more specifically set our council meeting coming up as well. But the question keeps circling back from last week. What impact does the Bostock case have on our local ordinance? That was the case in the Supreme Court, a 6-3 decision, where the court recognized that Title VII of the Civil Rights Act included protections for the gay and transgender community under the terminology sex, where you cannot discriminate in employment practices based upon race, ethnicity, and sex. The Supreme Court said, nope, that included the population who identify themselves as gay or transgender. You could not discriminate in either the hiring practices or in any discipline up to and including termination of an employee. So it was a very broad ruling in that capacity, but very narrow also, because it only applies to Title VII, which is employment discrimination. And the court went out of its way in its decision to point out that there were no other issues at this time before the court relative to public accommodations or relative to real estate or education, the components that we also have in our NDO. So the question becomes, do we still need our NDO? We have 4 sections of protection in the NDO. This has now been reaffirmed by the court, but the other 3 areas, as the court pointed out, are still not before the court and they've not ruled upon them. The court also addressed in its opinion the question of the religious exemption, which we debated extensively through the process of approving our NDO. The religious exemption, the court said, certainly is a First Amendment freedom, as well as the Religious Reform Protection Act, I think is the terminology. Again, the court said that issue is not before us, but the court went on to kind of reaffirm what we call the ministerial exemption. And that is employment by a religious institution that's specifically tied to the activities of the institution or the advancement of the theology or doxology of the institution is still protected. But again, the court said we would anticipate some question will come before us on that issue as to how these two interact with each other. Our non-discrimination ordinance did have the protected class for employment, but our non-discrimination ordinance also had a very specific exemption, protecting religious institutions in hiring practices, which would include discipline termination for positions involving the religious functions or activities of the institution. So a codification of the ministerial exemption. We still have 3 other sections of our ordinance, each with their own exemptions relative to religious institutions, all of which, if our ordinance goes forward, would still extend that protection, while maybe at some point in time the court or Congress catches up with that. Our options at our public hearing and then following that our council meeting are either refer it to the ballot and let the citizens of Gulf Manor determine whether they want to keep this on the books, or simply to revoke it. We don't get any other choice at the public hearing, the recommendation, and the following council meeting. The petitioners could withdraw the referendum petition if they felt that there was no need any longer to have a referendum. If you remember, a lot of the arguments we heard against our ordinance were focused upon its impact on the institutional employment within Gulf Manor and the Jewish community, which is now mooted, that argument, by this decision. So first of all, any questions on that relative to the case or our ordinance?
I think one thing to that we talked with the whole process was that, so as of now, if someone feels they're discriminated against under this ordinance, they now have the option to file a grievance or claim with Gulf Manor, and also an option with the federal level if they're over, what is it, 15 employees?
Well, they could bring a complaint to us and we would take it through our mediation process. That does not substitute for the right to go to EEOC or by extension, the Ohio Civil Rights Commission. And our ordinance even says that using our process does not stay any further process that you may want to pursue. So we are giving people an immediate outlet that is not necessarily there under Title VII. Title VII would force you to go to EEOC, file a formal complaint. They do offer mediation, but you're in the process of an investigation and a formal complaint.
But wasn't it my understanding that they only, it only applied to employers of over 15 employees?
You mean our ordinance or the
no,
federal?
No, the federal one, the EEOC in general, right? Most of
Well,
their things only cover that. So
I think what we're going to find with this ruling is any complaint, any employer, and they're not going to exclude the definition of employer necessarily. But that's up to EEOC, the guidelines as to how they tailor its enforcement relative to their jurisdiction. This just says you must include it as a protected class of persons.
yeah, because currently, or up till the Supreme Court ruling, the LGBT community could not even file per se with the EEOC because they were not a protected class under this. Correct? And now they are because of this. So now the EEOC is going to follow that.
The EEOC will have to follow it and provide the outlet for damages. That the EEOC did not have an outlet for damages. They were allowing complaints, but they were trying to reconcile those complaints. But now they are open jurisdiction for awarding damages, issuing fines, and so forth. So it's pretty sweeping what the court's decision was.
I still think the federal level, anything with 15 or below employees up till whatever, 3 or 4 or whatever it was handled by the contract through the state with the government. Anything above 50 employees was then a federal level suit. Is that correct? We don't know. We don't.
I really can't answer that.
Well, that's the way it was with, let's see, when I talked to them, yeah, that would be under employment. And when I talked to them, that's the way they said. They had a contract with the federal government to handle any claims with employers under 15 employees. Anything 15 or over was automatically turned over. They kind of worked together to it as a federal case. And then anything under whatever, I forget now, 4 employees, even they had a limit to that in terms of how small employer they covered. So I don't know if it's going to, we don't know yet if it's going to transfer over to that correct? In the same range.
I don't know. Our next step with the non-discrimination ordinance, we, by motion a month or so ago, we set a hearing for Tuesday, July 14th. Am I correct?
Correct. At 6 p.m.
At 6 p.m. And that was a meeting of the council as a committee required by charter, a committee to hold a public hearing on it and then make a recommendation. I'm going to recommend that we schedule a special council meeting immediately following that public hearing so the council can take action on the recommendation. And if it's going to go to the ballot, we can get that down to the Board of Elections so that there's plenty of time for those who are in support of or opposed to take their election action through the board.
So do we need a motion for that special meeting, or is it just something that I can call?
We can do a motion, or you can call it. If we have council here with a quorum and they are of the same mindset, we might as well do by motion, setting a special meeting of council that evening, immediately following the public hearing. So if the public hearing opens at 6 and we're done at 6:30, you immediately go into your council session. If it runs till 9 o'clock, you'd immediately go into your council session. But we would address that recommendation And then the recommendation would either be refer it to the ballot, and we will have legislation confirming that, or repealing it, and we'll have legislation confirming that to be available that night for council's action.
Well, I'm happy to go ahead and call that meeting. I think it's a good idea for the council to call it because it is the council that will be meeting as a special committee beforehand. And yeah, would like your input. So let's, I would ask for someone to make a motion.
Sure. Motion to call a special council meeting following the public hearing on 7/14/2020.
Second.
All right. All those in favor?
Aye.
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 I heard unanimity. Unanimity.
And what I will do is I prepared some summary of what I just talked about, and I'll give those to Mr. Hurth, and he can add those to the minutes, so he doesn't have to try and recapture everything, and then you'll have it in writing that you can review these points that I went over this evening.
Mr. Knipp, did you have something?
Yeah, I had a council meeting on the 13th. Is this in place of that?
It's an addition.
So we get 2 nights of council meeting back to back, and then you're done for the month of July, according to the calendar right now.
I've got another one on the 27th. Is that?
I think we could talk about that when we get to the next July meeting, if we need to have a second meeting in July, or whether everything that's on our agenda at that time.
Our current calendar is only one council meeting on the 13th with the addition of the special hearing on the 14th. So at this point, there is
nothing on the 27th?
There's nothing scheduled on the 27th.
Okay.
And you can always make that decision to meet again if we feel that there's business.
And one quick point, why did we vote all in favor? Yeah, we did all in favor. Okay. Before I request an executive session, some of you may remember there was a lawsuit filed against the village, and at that time our fire department, from a motor vehicle accident that occurred, I think Lozannaville and Montgomery Road, now 5 years ago, the accident. We made an offer to the plaintiff to settle her claim for a nominal amount of money. She rejected that and said all she wanted was an opportunity to address counsel. We gave that to her. The judge then said, ma'am, you've been given everything you requested. She then switched attorneys. She had originally been representing herself. The attorney voluntarily dismissed the case when the judge said that he was going to dismiss it for her lack of cooperation. And just 2 weeks ago, she refiled it, which is her right to do within 1 year of a voluntary dismissal. We are on the hook for that claim because it fell between our auto insurance carriers. We'll continue to defend it. I don't know that the nature of the claim has changed in any way, except it's back in the court system. We do not have a current offer on the table, and I'm not asking you for authority for an offer at this time, so much as giving you an update that we will continue to defend that case. With that, then, I'd like to ask council to make a motion to go into executive session for matters of personnel compensation, and then we do need a roll call vote on that. Then Mr. Hurth can put us in the private room.
Do I have a motion?
So moved.
So motion.
Who was that?
Second.
Who was the motion?
Roger.
Thank you.
Second was Ari. It was Eric.
And that's for personnel / compensation by statute.
For any folks that are watching, what this means is we're going to go dark for a little while. It's a private session that we're allowed to do under the law, and we'll be back for the completion of our council meeting following that.
Mr. Betcher,
Yes.
Ms. Cheney,
Yes.
Mr. Knapp,
Yes.
Mr. Krydnow,
Yes.
Ms. Snyder,
Yes.
Mr. Van Harn.
Yes.
Okay, I'm gonna move you all to the other room. Bear with me.